Next case on the docket is ARCOT versus BALARAMAN.
May it please the Court? I'm Catherine Swain, and I'm here on behalf of Dr. DILIP ARCOT. He is the appellant in this proceeding. It's an appeal of a final judgment of dissolution of marriage pertaining to various equitable distribution errors, child support calculation errors, as well as a relocation issue. And I'd like to address the relocation issue first with respect to the argument, and I would like to reserve 5 minutes for rebuttal. The problem with the relocation request was this was a case that had been filed in 2004. At the time that the wife filed the divorce petition, the parties were not living together at that time, but they had a child. They were both doctors. At the time of the filing, she and the husband were both practicing doctors in the Volusia County area. It was not until we started to prepare for trial that she filed a relocation notice on November 22nd, 2006. In that particular relocation notice, she did not state why she desired to move from Volusia County to Marion County, other than that she was seeking employment. She did not have a job offer. She did not have a place of where she intended to reside other than the general area of Marion County. She did not reflect that this relocation would increase her income based upon the change in venue. With respect to the evaluation of a best interest matter, there was a report done by Dr. Hoffman. He was a child custody evaluator with respect to the custody decision before the court. He did his report in August of 2006, 3 months prior to even knowing the wife was going to file a relocation notice. So he did not present any testimony to the trial court that the relocation was in the best interest of the child. And that's an overriding requirement of the trial court, is to look at relocation as from the child's standpoint. Was this in the best interest of the child to permit the relocation?
Well, you don't have to have somebody testify specifically that it would be in the best interest of the child, right? The judge can make that decision based on whatever evidence is presented.
That's correct. What happened in this particular instance is that there was no evidence that the wife would actually enhance her income. The wife testified that she was receiving about $380,000 in 2006 with Florida Memorial Hospital. The job offer that she provided to the court was an offer. It was not a signed contract between the offering oncology group and the wife. It was for $300,000 plus bonuses, and the wife had previously made over $500,000 at her current place of employment. In addition, the trial court seemed to emphasize that the wife would have more time to spend with the child based upon going to an oncology group versus practicing at the hospital, but there was no evidence that she would have a reduction in her on-call hours based upon the relocation. So there was nothing to show that this was going to enhance the time that the mom spent with the daughter based upon the change of employment, that the mom's income would increase based upon the change in the employment and relocation, or that the mom would necessarily facilitate visitation. If you review the lower court proceedings, there were many motions that were filed by the father asking for the mother to permit visitation. There was an agreement the parties entered into in 2004 saying, look, he's going to give you his calendar that he has for the month to show his hospital on-call basis, and we'll work visitation out based on that matter. That did not occur. There was constant acrimony between these two parties. Another problem with the relocation was that it did not facilitate visitation between the father and the daughter during summertime. There was no additional time given during the summer. He was provided 2 weeks during the summer. He practiced the Hindu religion. This was an arranged marriage by the parties. They were adults. They had allowed their families to arrange their marriage, so they were both from the Hindu culture. The trial court did not give any Hindu holidays to the father, which is in breach of his ability to raise his child in a religious upbringing that he's accustomed to. It's very typical for them to constantly, with Christians, provide Christian holidays, with Jewish individuals, provide the Jewish holidays. None of that was done in this particular instance. With respect to...
Is there case law to indicate it's an abuse of discretion for a trial judge not to, for example, divide up religious holidays?
There's case law that says when you don't permit the exercise of the religion, you have to show that there's emotional harm or some harm occurring with regard to the child, because you don't condition...
Doesn't that case law pertain to where the parents don't share the same religion?
No, actually...
One of them is X and the other one's Y.
No, I cited some in the brief. There was one that they were looking at. They were both Christians, I think, and the one was practicing the way, and the husband was arguing that was more of a brainwashing with regard to the child, and he didn't like that. He wanted to have a condition that she didn't continue on in the way, I think was one of the cases. So both of these parties were Hindus. So you're, by not giving the husband that Hindu, you're allowing then the mom to have all the holidays. That would be as if a Christian parent was there to give all the Christmases to the one parent, to give all the Easter holidays to one parent.
What was the schedule that was ordered generally? How was the contact schedule set up?
The contact schedule was that they split up the Christmas, they split up the Thanksgiving, basically took the school holidays and divided them, and then gave him 2 weeks during the summer, and he wished to have longer because his family all lives outside the country. So
and what about on a week or month-to-month basis?
No, and he specifically asked the trial court that he get every other week during the summer so they didn't have to continuously see each other. One of the issues between these parties was they were meeting at the police station because they could not do exchange.
But what about, did he get every other weekend, for example?
He was getting every other weekend.
Okay, so your comment that she gets all of the Hindu holidays, how none of them would fall on his weekends?
Well,
is that what you're saying? Or it would just be random whether he would have...
It may be random because the Hindu holiday is based upon stars, and they do occur in January, April, and October. So it's difficult to find that out before they align with the stars. The Hindus know how to do it.
Okay, but the schedule wasn't set up so that mom got all of the holidays. It was scheduled... It
was just silent.
Without looking at the holidays, so it was random whether mom or dad would have any given holiday.
Right. If it fell on his weekend, then so be it. That was it. There was nothing.
It's really a function of the school schedule.
That's what I said. It was a function of the school schedule. And with respect to the transportation, one of the issues the court looks at in the relocation is mom, if she's the one that's leaving the area, going to facilitate visitation. The mother offered to the trial court to transport the child one way. The trial court didn't even do that. It was as if the trial court was sanctioning the father in this relocation. Didn't give him any Hindu holidays, didn't say, yes, mom, you go ahead and transport the child 50% of the time. We're not going to give you a longer time during the summer. You keep on taking off work. We're talking a 3-hour round trip. Each time he goes to pick up the child and then return the child, he does 3 hours.
Did the trial court give any indication as to why he ruled that dad would do the transporting and dad would cover the expenses of transporting?
No. And at that time, mom was making more money than dad. So it wasn't a question of dad making more and it being a financial reason. With respect to the issue of the retroactive child support, that was another issue that the trial court ignored the evidence. The Cameron case is a case this court decided, and it said when you have before you actual income of the parties during the retroactive period, then you utilize that income. And it was clear that there was actual income. We put into evidence as a joint exhibit the parties' individual income tax returns for 2004, 2005, and we didn't have 2006, but we had W-2s. We also provided their state income taxes, which would reflect their income tax deductions for the Missouri state tax. We provide the nanny care. We provide the health insurance. They had all the information available to the trial court.
Was there any argument made below that any of those income documents or income figures were inaccurate?
The argument from the wife was that there was a different, depending upon which financial you looked at, then there was a different amount, but that was in keeping with their type of practice. They both received bonus income. Some were paid quarterly, so that would change based upon where.
Was there any argument made that there was income being hidden, that there were fraudulent documents, that the income tax returns didn't reflect all the income, anything like that?
No, they were all paid by third parties, so it wasn't a self-employment with respect to these physicians. So we made the argument that the trial court could not go back and use, and it wasn't even a present income the trial court utilized in determining the retroactive child support. The trial court pulled the wife's income that she may make if she did obtain the employment through Ocala at $300,000, and at the time of the trial she made $380-something thousand, and it gave a different income to the husband based upon what he was making when he started the next year as opposed to utilizing the prior year. With regard to the issue of child support credits, the trial court also did not give any credits to the husband for paying child support. The wife concurred in her brief that there were child support credits due to the husband, that he had paid child support. The husband never stated he did not owe child support. One thing the court needs to recognize is these parties were off again, on again. During the filing of this particular proceeding, they actually entered into an agreement to go to counseling, to try to get an accounting of their assets, etc., and that was in 2004. The husband said, look, I'll go get a nanny and employ one so that I can have the child at my house more often, so I can leave her there in case I get called back to the hospital. He testified.
Isn't there a concession that there was $8,472.73 that should have been credited? How much more than that are you saying should be?
No, we concur. I said in the brief she did acknowledge that the trial court erred, but on rehearing the trial court didn't revise that to show.
But is that the figure, or is there more in addition to that?
No, I think it was what we both concurred in the brief.
So that's the figure then, right? Everybody agrees with that, and there's
right.
no more that anybody contends was owed? All right.
That's correct. With respect to the different equitable distribution.
Let me ask you a question about the child support arrearages. I think there was an argument made about whether or not there should be interest applied to that.
Right.
Is a child support arrearage different than how you apply prejudgment interest, for example, in a civil matter when an amount is ultimately liquidated? Even if you have a dispute on a contract, whether any amount's due, what the amount is due, ultimately the rule is once you say, okay, you owed us X dollars and you owed it to us as of 5 years ago, you get prejudgment interest. Is that not the way it's done with regard to child support?
Okay, it's a little bit different. With the Vick case, what it said is you have to basically know that the child support is an amount owed. So once, I don't disagree that there's a judgment that interest that accrues from the date the court determines the amount. But at the time that from 2004 to 2006, there was no existing child support order. So there was, in fact, they were still fighting about, and we're still fighting today, what that amount should be. So there's no ability to run the interest until there's an actual order entered saying that this is the amount that's due. Yes, then you run the interest. We went to a general magistrate hearing or general master hearing, I can't remember which it was at the time, and she refused to determine a retroactive award, so there was no retroactive award made at that time. It was not until the judgment was entered in 2007 that there was an actual determination of a child support arrearage, and from that date forward you do it, not from 2004, 2005, and 2006.
So based on your analysis of the law, there's no incentive for somebody to pay child support early, right? The incentive would be to hold off as long as possible because you get the time value of money because you're never going to be tagged with the interest on the money you don't pay.
Well, I think if you may have had a scheming parent, yes, but in this particular instance, we didn't have that. The husband was actually even paying $500 a month toward a retroactive child support, whatever that amount may be, when he started paying child support, because he got mixed messages from the wife. You don't need to pay me child support. She was making over $500,000 a year. And so, we're reconciling. So he was concerned about, do I owe it, do I not? There was a lot of money that was disappearing prior to the filing, and that's why they were seeking an accounting. Granted, the trial court said the forensic accountant couldn't come up heads or tails with a number that either party was due based upon the limited documents he had, because they were trying to go back to 1993 when they first got married, which was a futile effort.
Let me ask you about another issue, and that relates to a college fund. Explain to me how the college fund was dealt with and
and how it was allocated.
The father started, well, actually the mother started. They talked about having a 529 education account for their daughter. The 529 education account was acquired during the marriage. It was funded by the father's salary. It was supposed to be placed in both parties' names, but the wife created the account, put it solely in her name. The trial court awarded the 529 account to the wife. And that's where the wife complained that she shouldn't have had that. It should have been set aside, not considered part of the marital assets. On the flip side, when you have a 529 or a Florida prepaid account and there's a constant liability, the court says, all right, that's a marital liability, we're going to assign it and distribute it. So this is just the asset side of that equation, and the court has the discretion to take a marital asset because it was acquired during the marriage. It was in the name of the wife. The wife could at any time cease that 529 account. She could then keep the money herself. She had already shown to the husband her desire.
So there's nothing that prevents the wife from using that for something other than the education of the child?
Right. I mean, you can, on the education plans, you can always stop them. You may have tax consequences, but if you are the primary title holder, you have control of that account. One of the other errors that the court made was with regard to the Chennai flat.
Let me ask you one other issue that I was a little confused about. There was a moving expense reimbursement.
Right.
Explain that to me.
What the wife testified was that she incurred $13,000 to $14,000 in relocating from Missouri to the state of Florida.
During the marriage?
During the marriage. It was an actual relocation to here, to Florida, which occurred right before she filed. It was several months before that. She testified she received the $10,000. The forensic accountant, Thomas Behan, had the records of the parties during that period. The wife testified that she deposited the monies into the account. Nowhere could those monies be found in the deposit records of the account. Now,
she said she deposited into accounts that were then ultimately equitably divided?
Right, but there was no evidence that that money ever came into those accounts. So whether she cashed it, maybe she put it into another account, but there was no tracing of that $10,000 during the period that the money would have been reimbursed. It was in her contract with the hospital that she would receive reimbursement, and she acknowledged that she did receive the reimbursement. She utilized marital funds to move, so she just didn't redeposit those monies back into the marital accounts. It was similar to what she did with regard to the checks that she received from the hospital. She had 3 checks on her pretrial compliance. She acknowledged that they were marital assets, that she had those checks, that they did not go into the accounts, but then she didn't like the fact that we would ask that they be considered marital assets. The husband's money, on the flip side, was going into a joint account on a regular basis being deposited, so it was accounted for in those marital assets that were distributed.
You're down to about 3.5 minutes if you want to say
I'll
it.
stop. Thank you.
May it please the court, my name is Joan Stefanik Briggs of the law firm Adams, Briggs & Briggs in Daytona Beach, and I represent the appellee, Dr. RAMA, BALARAMAN, and also represent her on her cross appeal.
There are a whole bunch of issues here, so let me start by seeing if I have a correct understanding of the errors that you all concede. As I understand it, there are certain errors that you agree were made below. Do you agree that there was a bank account that was improperly counted twice? And even though you disagree with the other side about which of the 2 numbers to use, is there any dispute that one account was improperly listed twice?
That is correct. It was listed twice.
Okay. Do you also agree that there were some credits against the child support arrearages that weren't included that should have been included?
Correct. And the numbers in the brief, the 8,000 and something.
Right. And do I correctly understand that part of the child support ordered to be paid by the husband was to pay to the wife for providing insurance for the child?
That is correct.
And was there an agreement, or does the judgment require the wife to have insurance on the child in exchange for getting the insurance premium? Because I thought I understood one of the arguments to be he's required to pay her for the insurance premium, but she's not required under the judgment to actually carry insurance on the child.
That relates back to this case has been litigated for 3 years, and many details were left out regarding health insurance. We'll concentrate on that. The health insurance issue is the father would never give the mother a card. He doesn't pay for the health insurance at all. Out of frustration, she went out and got health insurance for the child. The judge had to deal with these people for 3 years in every petty little argument. He stated that this insurance costs Dad nothing. If it cost anything, then Dad can get rid of it. So if Dad came back and said, it cost me $1, here we are going back to court asking for this insurance to be taken away or Mom to have the insurance. The judge stated the mother can keep the insurance. Didn't say thou shall, but the indication was there was no problem with her having the insurance based on the problems these couple had regarding getting coverage and insurance card for this child.
Is it your understanding that she is required to maintain insurance on the child under the final judgment?
It doesn't say the word shall.
So she doesn't have to carry insurance if she doesn't want to. Is that correct?
That would be correct.
Is it also your understanding, however, that in calculating the amount of the child support, the premium for those insurances were included in the calculation?
Yes, it was.
So under the current arrangement, the husband is required to pay a portion of an insurance premium for a policy that the wife has the choice of whether or not to carry on the child.
And she's had this ever since for years. It's not like she's had this throughout this whole litigation.
She's had what? The insurance?
The insurance,
okay.
Correct.
But she's not required to?
No, it does not say thou shalt carry it.
That was the intent of the trial judge, though, wasn't it? I mean, if he's going to pay, that she's got to use that money for the insurance, right?
Correct. That was his intent.
Right.
But if you're asking, was it mandatory, was the word shall used? No. But it's the intent that please don't come back to me if something happens with the father's insurance. Also, this woman is not even living here. We don't even know if the insurance that he has through Halifax Hospital covers this child in Ocala.
Let me shift gears to one of the other issues, that being the relocation issue. Did the trial court give any reason for not setting up an arrangement where they somehow share in either the expense or the time of the transport between Ocala and...
I think you'd have to go back and look at one of the other discussions and disagreements, and it's in the record. One of the others was the transportation problem that they were having. First of all, this father was not involved in this child's life from 2000 to 2003. And when she relocated to Florida prior to him being here, he had very little contact with her. And the judge even says, my goodness, when Mom moves to Ocala, the father's going to have more contact than this father has ever had in the lifetime of this child. But the mother is involved in research, and there had been a problem with the father doesn't schedule his visitations to the last minute, and based on the fact she needs to travel out of state due to her research, she uses these weekends that the father has him to do her research elsewhere. And this was not brought out in the trial, but in the trial record there is discussion regarding the transportation, and there is a basis, as the judge had heard previous testimony regarding the difficulties with transportation with the visitation.
Let me ask you then a question about the child support arrearages. Are arrearages to be, if there is a period of time in which child support has not been paid, and now you are at trial where the court is to determine arrearage, is the trial court supposed to do that based upon what the current income of the parties is, or is he supposed to look back at the years of arrearage and look at what the income was during those years and calculate for those years how much the child support would have been?
What the judge did is he was confronted with all these different numbers. This judge did look. He goes, okay, I'm going to look at the financial affidavit. It says something different versus what the tax returns say. Go to the general magistrate. You look at her report. It also says, I don't understand, what they want me to base their income on. I guess I'm going to do it what's on the financial affidavit, even though in past years they made more, but nobody's making the argument. And if you'll look at that, you'll notice that the judge says in the final judgment, No one argues retroactive child support, yet at the very end, they want to argue it. So he gave them time after the trial to submit child support worksheets. So here we go again with the old arguments. Which salary do we use? The judge says, I will use the salary that both parties testified to. Father testified $250,000. Mom testified $300,000.
Current salary?
That is correct.
Did the wife testify that her current salary was $300,000, or did she testify that in the future she was moving to a job where her income was going to be $300,000?
She testified that was going to be her income, $300,000.
Did she testify what her income was at the time of the trial? Or leading up to the trial, as opposed to looking into the future as to what it was going to be down the road?
The actual verbal testimony was $300,000, $250,000, although there were documents that showed their income was different than those amounts, meaning looking at their financial affidavit, and there was multiple financial affidavits and the tax returns. There wasn't one specific document. These parties didn't stipulate to anything. There was nothing that pointed out other than the judge saying, they testified to these incomes, these are the incomes I'll use. And if you'll note, when he used those incomes, as in the cross appeal, he didn't order the husband to pay any of the interest that accrues. He allowed him to pay the $61,000 in past child support at $500 a month. The wife's entitled to statutory interest on that amount. And on the $61,000, it's $33,000. She didn't get it. One is offsetting the other.
Entitled to the interest going forward or calculated back over the period of the arrearage?
That is from the date it was ordered going forward. In the brief, there's an appendix that shows the amortization of from the date it was ordered, how much interest based on what statutory interest was.
But you argue they were also entitled to some interest looking backwards, right? Some pre-award
I did,
interest?
and based on case law, I'm not so sure that's correct. On the $33,000, that is correct. She is entitled to that, or whatever the statutory interest. All the judge had to do was say, paid at the statutory interest rate, which we all know changes, but it was 11% back then, and that was what I based my amortization schedule on. $33,000 is what he should be paying in addition to that arrears in order to comply with law. In regards to relocation, it's incorrect when the husband states that the wife had a job at Memorial Hospital that was secure. You'll find testimony that they started out with like 5 oncologists. By the time she came to trial, there was only 2 left. She was on call almost constantly. She also, you'll see the deposition of the CEO, Gentry, was entered into evidence. He did not, as the judge says in his final judgment, give any sense of security that the wife would have a job tomorrow. In fact, he didn't even know that she had been fired, but was still working until she could secure other employment. You'll see that the father, during this time period that they were living in Florida, both of them, had very little contact. Dr. Hoffman stated that he talked to 2 of the teachers of the child. They had never seen the father. They had never had any contact. And they go, this is very unusual. Never even emailed. I mean, parents email all the time. Absolutely no contact, and how that was very unusual. Also, Dr. Hoffman tried to schedule an appointment with both mom and dad present. And he goes into the difficulty, and he said mainly due to the father refusing to cooperating. It was because of the extremely poor communication between this couple. Dr. ARCOT, the father, admittedly refused to respond to any of his wife's communications to arrange a mutually agreed upon date. Only until his lawyer gets involved does he get to see this couple together. Also, based on Dr. Hoffman's finding, he found that The mother was the one that had the expectations for the child. She's the one who ensures that the child's education is prioritized beyond her own career as a physician. Because you hear the husband claim we moved for the wife. It was independent people, experts stated this is not true. And as the judge found in his final judgment, this will be far more time that they have had together since she's been an infant, even with the mother relocating. So there was substantial, competent evidence to support the judge in his ruling and allowing her to relocate. In regards to the equitable distribution, if you look at the equitable distribution sheet submitted by both sides, you'll see on this sheet that the father and the mother both agreed that that college fund would not be counted in the wife's equitable distribution, rather that it belonged to the child.
Excuse me, I'm still a little bit confused about the sums that were used to, that were adopted by the court in terms of calculating the support obligation. You said that the testimony was that she was making $300,000, but there's also in the record evidence that it was $380,000 at the time that she may be earning $300,000 in the future. Where exactly does the $380,000 figure come from?
That was what she had earned in her job. That was insecure. Unsecure was not a secure job. She got bonuses. The bonuses were lessening over the years, and she wasn't sure the oncology department was even going to exist at Memorial Hospital. But that wasn't a base salary. That was, she had a base salary at Memorial of $200,000 plus bonuses. But there's
so in other words, the trial judge knew that she, at least for 1 year, she made $380,000. Yet he used a figure of $300,000, which he expected her to earn if she were to take this job in Ocala. Is that right? Am I following you?
That is correct, but also the judge was not presented with the issue of retroactive child support during the trial. And you'll see in his finding, neither party filed a calculation worksheet during the trial. Therefore, the amount of retroactive award was not raised. Now, here we have after trial, when he asked, I don't know what I'm supposed to decide in this case. So this is what he said about the child support.
Well, I still don't understand why it wouldn't have been appropriate for the trial court to use the $380,000 figure rather than the $300,000 figure. I'm having a problem with that.
He was presented with various incomes during this time period.
It says the court, the judgment says the court has adopted. It sounds like the court's kind of imputing rather than, going on what the party's actual earning history was. And the actual earning history was, at least for 1 year, $380,000. He uses some figure of $300,000 that she may earn if she goes to work for Ocala Oncology.
If you look at the final judgment, this is a quote from the judge. The parties' incomes are different every time they file a statement, and that's on 775, 785, the final judgment. As a result, the trial court used, this is the quote, the income testified to by each party. Again, that's found in the final judgment. He's presented with different figures.
Now, are you saying by that at different times their income was different, or they were representing their income for the same time period differently at different times? Do you understand the distinction?
It was represented differently at different times.
So what he's saying is not that the affidavits are ever moving because their income is changing, but that they're inconsistent.
They're inconsistent. And that's what this judge was confronted with the whole time. He dealt with the case for 3 years. In December, right before the trial, 6 weeks, he goes, I'm going to appoint a special magistrate to help me with this equitable distribution. The special magistrate comes up with what they need to exchange with each other, makes a ruling, everybody's present, everybody agrees. Then the husband files exceptions to it. Then we have the CPA come in that's both their witnesses. He's scratching his head saying, I don't know why they hired me.
So because the incomes were inconsistent, that's why he adopted the $300,000 figure that she was going to be earning at Ocala
Right.
Oncology?
The judge says-
Is that basically it? Is that?
This is the income testified to by each party. That's what he based that on.
Well, isn't that number satisfactory if he was to be going forward for future child support until the number actually gets established? But with past child support, I mean, at the very least, you've got the tax returns that the party filed. And so irrespective of their financial affidavits, it seems like the tax records would be the best, most accurate of what their actual income was, since as I think you said, it was all coming from third parties.
I think it's easy for us to sit back and criticize, but we're talking about information that was presented at the very end. He's dealing with all this mess. He's trying to get information from these people. At the very end of the trial, he goes, I don't even know what the issues are. And it wasn't until the end. Yes, I agree, but nothing was ever presented or stipulated to. There was always disagreement on every insignificant issue.
The retroactive amount was calculated on the 300 rather than 380, wasn't it?
That is correct, but she didn't get statutory interest. So that's, one's offsetting the other. We're talking $33,000 that was not awarded to her that should have been. According to this court's invit, also according to the statute, 6114, statutory interest should be included in arrearage amount.
Let me have you address this issue about the 3 checks that are in dispute. As I understand it, the judge determined that he would use a December 31st date as the date for valuing the assets and determining the equitable distribution. Is that correct?
That is correct.
As of December 31st, what was the status with regard to these checks?
If you read, the wife says, I tried to deposit those directly into the account. For some reason, the bank here in Florida would not take the checks.
They predated December 31st, is that correct, the checks?
December 31st of 2003, yes.
Okay, so the checks predate, they were issued prior to that
correct.
date.
You are correct,
And
yes.
as of December 31st, were they just sitting uncashed? Or what had happened to them?
I'm not sure exactly what happened, other than the fact that she had tried to deposit them. I'm not sure they were deposited at that point, but the judge also offsets this with the fact that she was not receiving. He only went back 36 months on the retroactive child support. He didn't go back to when she was supporting this child. And she was unemployed during a period of this time. So he said, I'm not counting this. Besides, she did not receive any support from the husband during this period of time.
During the period of time covered by these checks?
Yes, which was 2003.
And that's the reason the trial court gave for not counting the checks?
That is correct.
All right. And that was not a period
Covered by the arrearages.
That is correct. It was not covered by the arrearages. No, it wasn't. Well, it's the wife's opinion that the judgment should be affirmed on appeal.
Thank you, Counsel. What's your response to the argument by opposing counsel on the checks that the trial judge offset it against a period in which he didn't give arrearages, and so that's why he didn't count the checks as part of the marital distribution?
His statement was basically it was post-separation, which was not the proper reason for determining those to be non-marital assets. In actuality, the wife lived off over $21,000 of joint funds during the period that she did not receive income from the husband. The husband knew she was coming down here. Remember, he moved her down here. He was coming down to the state of Florida as well. They left the accounts open. She was drawing down from the joint accounts for that time period. And so if the court was going to do that, then he needed to look at the $21,871 that that she utilized from the joint accounts because her salary checks only totaled $11,000. Her salary checks were held back. They were not deposited until after the December 31st time frame. In the brief, I cited to where the statement actually showed the exact dollar amount where it went to deposit on one check and the very close to the two other checks being deposited post December 31st, 2004. With regard to the issue regarding the retroactive child support, I'm somewhat surprised about the judge's remark that nobody argued retroactive, because what happened was we finished evidence. He asked trial counsel to submit closing arguments. I submitted a 14-page, single-spaced closing argument going in detail through each of the various issues. Opposing counsel filed a closing argument. We both filed with our closing arguments retroactive child support calculations. When you look at those and compare the worksheets, the biggest difference between the worksheets isn't the actual income, but it's the nanny care. We were arguing that the nanny care should not be $1,500. It should be like $900. Wife's counsel was arguing it should be $2,000, and nanny care or daycare, that amount will drive up child support. So that's where the biggest issue was. It wasn't in the amount of the income. You'll notice that we filed a joint exhibit number 1. That was the income taxes of both parties for the Missouri as well as the federal state income tax returns. So the court knew we both were talking about. We both filed joint exhibits. We addressed it in closing arguments. We addressed it with worksheets. So for the court to say I didn't know they wanted to do that, I couldn't understand the income, is not a fair assessment of the evidence before the trial court. With regard to the visitation issue, you have to look at what happened in this particular proceeding. There was constant movement by these parties, and much of the movement was started by the wife deciding to make a career move. She would decide, I want to start a fellowship, I'm leaving Australia, I'm coming back, I want to come back to Missouri. Husband would find a job. She would work there, then she wanted to move again. She kept moving the child. The husband had to keep on changing his schedule to try to come and see the child before he got another job, and this was a constant issue. And one of the reasons he objected so much to the relocations, we're finally here in the same place. Don't let her move that child again, where I have to constantly try to rearrange my work schedule, get in the car and drive. And that was what he did. He did that in Missouri. She came to Florida. He had to, once again, he hadn't had a job contract completed here. He had to drive back and forth from Missouri to Florida to see this child, and he was constantly trying to find the time to see the child because of the distance between the two. And he had a schedule provided by the hospital. What you'll notice is that the big issue with it is notice. If you look at Dr. Hoffman's report, he says one of the issues on the visitation is he wants a month advance notice. That's all he's going to give. Well, he got his schedule at the hospital a month in advance, so he would know, and then sometimes it'd be a short time period to let her know that, well, I can have it off this week coming up because I just got my schedule for this month. So the biggest problem between the two was scheduling the visitation, not him exercising. He kept exercising the visitation, and she even bribed him one time and said, look, I'm not going to let you have your father see the child unless you sign a note saying you owe me $200,000. You're going to let me go to India when I want to. She was, having him sign at his car on the wheel a note saying that, so just so he could have visitation with the child and let his parents see the child.
Thank you, counsel.